CR 10343, State of Texas versus Elisa Marie Herrera. Can I have parties announced for the record for the state? Defense.
Warren Wolf, Ms. Herrera.
And Mr. Wolf, you're on this side for security purposes. And are you Ms. Herrera?
Yes, ma'am.
Did you review the document entitled Motion to Revoke Community Supervision with your attorney? Did
Yes,
you
ma'am.
understand it?
Yes, ma'am.
Are you the same Elisa Marie Herrera who's placed on community supervision in 2022 CR 10343 for the offense of possession of a controlled substance, penalty group 1, 4 grams to 200 grams on December 20th, 2022 for a term of 8 years? Is that you?
Yes, ma'am.
All right, state.
Violated condition number 4 in Bexar County, Texas, the defendant Elisa Marie Herrera, then in there failed to report to the supervision officer as directed on the 17th day of June 2024 in violation of condition of performance.
How do you plead to that? True or not true?
Sure.
Your Honor, state waives all the violations.
Any objections to the state's waivers?
No, Your Honor.
Did you understand by pleading true to violation of condition number 4, the court could find it true, grant the motion, sentence you up to 8 years in the prison and up to $1,000 fine?
Yes, ma'am.
Knowing that, do you still wish to plead true to violation of condition number 4?
Yes, ma'am.
Court is going to find violation of condition number 4 true. Is there a proposed agreement?
Yes, Judge, the proposed agreement is for safety followed by applicant.
And that's our understanding, Judge.
All right,
We're in
why-
agreement.
Why should I follow that? Because hasn't she been to felony drug court?
Felony drug court has a lot of requirements and very onerous.
Yes.
She was doing well there. She had completed safety, just had a relapse. It happens. I know Judge Glenn understands that. The thing that triggered all this really is the fact she took her monitor off, which is another allegation. But just so that she was staying at home. She was arrested at home. It was just so burdensome that so now she's facing coming back here and looking at being, if you do follow the recommendation of the probation office, being locked up.
I will tell you, I'm not going to continue her unless somebody from felony drug court wants to zoom in and says, we think this would be best. Because felony drug court, yes, it's a stringent program. They're trying to get you to be clean and sober. And if you're not following their rules.
Right here, the judge draws a hard line. Relapse alone isn't the deal breaker. Courts understand recovery isn't perfect. But removing the GPS monitor changes everything. To the court, that's not struggling, that's rejecting supervision. And once trust is gone, probation stops being an option and prison becomes the only path left.
Then there's nothing I can do for you, because at the end of the day, I can't monitor you as closely as they can monitor you. So prison may be the best thing for you. You had choices to make and you made choices. Felony drug court does not remove someone from the program based on the fact that they had a relapse. They understand that sometimes in people's lives, relapses occur. But this other thing that your attorney is mentioning about the removal of the GPS, yeah, you probably shouldn't be on probation. You should probably go to prison.
Well, she is, she's been sitting in jail now for about 50 days. She understands her circumstances. I've explained to her what a trip to TDC would do going forward to her record. She is committed to making a success of her probation, and she's asking for that opportunity.
Well, I'm going to revoke her. Do y'all want to speak to time? The court could sentence her up to 8 years.
I'd like to get her how much credit she has, Tony. 165 days.
I mean, if she successfully completed inpatient treatment, I'll give her credit for successfully completing inpatient treatment. But if she didn't successfully complete it, then she's not getting credit.
It's in the probation report.
Okay. Any objections to the court reviewing the probation report?
No.
Yes. So I'm reading the court summary, and in the court summary, it says that you tested positive for cocaine, you admitted to using, and so they tightened your sanctions. And then you didn't call the UA hotline. One time you called late, and then you failed to submit, and then you had another positive, and they gave you sanctions instead of removing it from the program. So they understand that, but when you're not trying at all, there's nothing they can do, and you were not trying. So probation, did she successfully complete inpatient treatment?
Judge, she was in status 175 days, and that was successful.
All right, so I'm going to revoke, sentence you to 6 years in the prison, give you credit for any time served, and credit for any time served for successful completion of inpatient treatment. And let me see. There's $1,000 fine. Time and money will run concurrent. All right, was the restitution paid to the Bexar County Crime Lab for UAs? For testing of the drugs? Did you pay $57 to?
No, Judge.
All right, so there's to be restitution of $57 to the Bexar County Crime Lab for drug testing. Or I should say for the testing of drugs. All right, did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand it and sign it?
Yes, ma'am.
All right, you have a limited right to appeal, and that right to appeal is as it relates to the allegations in the motion, not the fact that you are on community supervision. Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what a weapon or ammunition is, you'll need to speak to an attorney. And counsel, what I'll do is I'll recommend the therapeutic community.
Thank you.
You'll have to ask for it as well, because I have no jurisdiction to force you to have them force to take you into the program. It doesn't increase the length of time that you are in the prison, but at least it will give you hopefully some tools so you will not be back here for drug use. You understand?
Yes, ma'am.
We can go off the record. When you're released from prison, if you don't know where to go, if you don't have a place to stay, if you don't know where to get treatment, if I'm here, you can still come back here and I will guide you and pick up the phone and call people who can help you maintain your sobriety.
Yes, ma'am.
All right, good luck to you.
Thank you.
You're welcome.
Judge, I had another matter
Yes.
I wanted to address.
CR 7878, State of Texas versus Augustine Adam. Can I have parties announced for the record for the state defense?
Marissa Giovanco for Mr. Adam.
And are you Mr. Adam?
Yes, ma'am.
Excuse me, Yaya, could I have the file stamp for a motion to revoke?
Yeah.
Thank you.
I have my copy. You want my copy?
All right. Mr. Adam, did you review the document entitled Motion to Enter Adjudication of Guilt and Revoke Community Supervision and First Amendment Motion to Enter Adjudication of Guilt and Revoke Community Supervision with your attorney? Did you understand it?
Yes, ma'am.
Are you the same Augustine Adam who was placed on deferred adjudication in 2022 CR 7878 for the offense of assault, family choking, strangulation on September 16, 2022 for a period of 4 years? Is that you?
Yes, ma'am.
All right, state.
Judge, before I read it, I just want to make sure that you're aware that there's also another case that is in between the two. I don't know if-
Yes.
Okay.
I have that.
Thank you. Yes, Your Honor, violated condition number 4 in Bexar County, Texas, to defendant Augustine Adam. Defendant there failed to report to the supervision officer as directed for the months of January and February 2023. Violation of condition number 4.
How do you plead to that? True or not true?
True.
And we waive the remaining violation condition, Your Honor.
No
Any
objection. No objection.
Did you understand by pleading true to violation of condition number 4, the court could find it true, grant the motion, find you guilty, and sentence you up to 10 years in prison and up to a $10,000 fine?
Yes, ma'am.
Knowing that, do you still wish to plead true to violation of condition number 4? Do you understand? Because I want the record to be clear and to make sure that you understand whatever agreement that you worked out with the state, the court does not have to follow that agreement. Do you understand?
Yes, ma'am.
The agreement that may have made with the state, that's just a recommendation for the court. Do you understand?
Yes, ma'am.
Knowing that, do you still wish to plead true to violation of condition number 4?
Yes, ma'am.
Court will find violation of condition number 4 true. Is there a proposed agreement?
There is, Your Honor. And it is to deny the motion and continue the individual on his probation. And to run this concurrent with cause number 2023 CR 5176, which is the criminal mischief state jail.
All right, is that the proposed agreement?
It is, Judge, and Mr. Adam, the criminal mischief that he is pleading to was prior to his probation. Mr. Adam has told me that he did have some struggles while he was on probation. He found himself homeless and he struggled with no cell phone and contacting his probation officer. He fully understands now that that is not an excuse and that he has to fully participate in his probation. He is motivated to do so. He has another child coming and he has never been to prison. He does not want to experience prison for the first time. He wants to be able to be here for all of his children, including the new birth of his new child. And there is a significant amount of restitution that is owed based on the criminal mischief case. And he is understanding that and prepared to do what he can to gain employment and work on paying that restitution.
All right. Do you have anything you wish to say?
No, ma'am.
All right. So where has he been since 2023?
It's my understanding, Judge, that that's when he was homeless. I don't know if he wants to speak on that himself, but
I didn't have nowhere. I was.
You want to
living on
raise
the
your right
streets.
hand for me, please? Do you solemnly swear or affirm the testimony you give would be the truth and nothing but the truth, so help you God?
Yes, ma'am.
All right, you can lower your hand. Where have you been?
I've been living on the streets by myself. Like I was
Living on the street since when?
since 2023. My own family threw me out when I had my other kids with me. That's how I ended up on a CPS case, and I went bottom hill from there. Like I was going through depression.
All right, but you have a child that's on the way.
Yes.
So I'm assuming, since you have a child on the way, that child has not been in gestation since 2023 because the months don't add up.
No,
So-
this child that's coming is just a recent child that
So help me understand, you're homeless, which means you don't have a place to stay, but yet you continue to have children
that's not.
and you're homeless.
I do certified contracting,
Okay.
so that's like
And who is the mother of this child that's about due?
her name's Laura. I don't know. I don't remember her last name. It's
So you're having a child with somebody, you don't even know their last name.
this one.
Okay. Any other questions?
no, Judge.
Has he done anything on probation? Ms. Abrams?
No, Judge.
All right. Court is going to grant the motion, find you guilty. His range of punishment is up to 10 years in the prison. Would you like to speak to the amount of time, counsel?
Judge, we would ask for the minimum of 2 years.
All right. Court is going to find you guilty. The court will sentence you to 5 years in the prison. Give you credit for any time served. There's an affirmative finding of family violence. There's to be no contact with Destiny Cardenas.
I have no contact with her no more. We went our separate ways.
I'm sorry, what?
We went our separate ways after that.
All right. All right, did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand it?
Yes, ma'am.
And did you sign it?
Yes, ma'am.
You have a limited right to appeal. That right to appeal is as it relates to the allegations in the motion, not the fact that you are on deferred adjudication. Do you understand?
Yes, ma'am.
All right, because this is an affirmative finding of family violence and a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what a weapon or ammunition is, you need to speak to an attorney. Do you understand?
Yes, ma'am.
All right. Do you all still wish to proceed with the plea bargain agreement that's been reached?
We just step back for a moment.
Yes.
Okay,
All right. You have a seat in the box.